I'm going to take a moment and introduce Diana. Diana is a practicing attorney. She's been, this can't be right. She's been practicing since 1996. That's find that hard to believe. Joined the family law firm and is now president of the firm. And since joining Payee and Moak PC, her practice is concentrated on probate and estate planning, special needs planning, trust, estate administration, and corporate formation and succession planning, and real estate. Diana has quite a list of accreditations. She's an outstanding attorney and has spoken to us a number of times to give us an update on how to work out your estate planning and some of the pitfalls. The other thing, and she's going to mention it, we do have a website that we found for those of you that aren't in the Michigan area. Her expertise is in Michigan and estate planning in the state of Michigan. But there is a website you can go to get information on each individual state, some of the specifics. And the other reason we're doing this presentation at this time is come, I believe it's November timeframe, you'll be able to sign up for your Chrysler or Stellantis benefits. And one of those is legal services that I believe is on the order something like $25 a month. And part of that, you can get your trust and will established. So it's a really good deal. You can sign up for it for the year. And at the end of the year, when you have your trust and all in place, you can drop it and you only pay for when they're doing work for you. So with that, I'm going to turn it over to Diana and let her get going.
Well, hello. So yes, as Dale said, everything that I'm talking about is really based on Michigan law because I'm only licensed in Michigan. So just to be upfront and clear about that, I'm talking primarily about Michigan law. And besides that, the website that he was referencing is NOLO. It's NOLO. And that's generally a good resource to tell you about the same type issues in your state. So if you do go to that, that's one source. Another source is to check with your county for your local bar association. And so that's what an organization of attorneys is called, is the Bar Association. And so if you Google, like for me, it would be Oakland County Bar Association, that will give me some links to local attorneys who may be able to answer my questions. Additionally, if you do have the MetLife legal plan, you can call or go online with them and they will set you up with a local attorney to you. Or for instance, if you're a Michigan person who has a property in Florida and you have questions about your Florida property, you can tell them that you want to get put in touch with an attorney in your Florida area. So that's another good resource and another way of finding attorneys who have been screened and that MetLife believes are competent attorneys. So just to keep that in mind. These are the topics that I'm going to be talking about today. So I'm talking about what's new. Just a brief update because there's not a whole lot new since the last time I gave this presentation in 2020. Part two, what documents should I have, is really where I spent most of my time in 2020. So I'm going to try and go through that sort of quickly so that we can get to some of the other topics that I didn't talk about as much then. And I know that you're able to access the 2020 seminar through the recording that was made at that time. So we will talk about what might need to be changed, how to avoid estate taxes, which your clue is it's pretty easy right now, and what's required for probate and trust administration, which I've never talked about with this group before. So that's something that might be more interesting and we may spend more time there. We'll talk about your MetLife legal plan, and if time permits, we'll talk a little bit about Medicaid. Again, there aren't a whole lot of updates there, but the figures change on that every year. So what's new? The 2022 estate tax exclusion amount now is $12,060,000 per person. And so if you're married, that's $24,120,000 for your couple. So what that means is that that's how much you can leave to people without paying any estate taxes. So if you're single, you can leave that $12,060,000 to anybody you want and not pay any estate taxes. If you're married, you can leave $100 million to your spouse because there's an unlimited marital exemption. So as long as your spouse survives you, like Bill Gates could, well, I'm not even sure they're still married. Bill Gates and Melinda are still married, I think. They could leave everything to each other and there would be no estate taxes on the first death. Then on the second death, that's where the issue of estate taxes really comes up. So we'll talk about one way to avoid estate taxes on the second death, which is portability. And what that basically means is that you may want to file an estate tax return for your spouse, even if you're not legally required to file that. And so we'll talk in more detail about that as we go through this. Old news, but it's becoming more relevant, is that in 2026, the estate tax exemption is going to go down to that $5,490,000 adjusted for inflation. So if you think about it, it's about $6 million. Inflation's high right now. Maybe it'll be slightly more than $6 million. But if Congress does nothing, the estate tax exemption is going to go down to 2026. So the odds of Congress working together to raise the estate tax exemption are a little iffy. But I guess the good news is that we were worried last October that with Build Back Better, the estate tax exemption was going to go down even lower than that, or go down to the 6 million even sooner. So what this means is that if you do, as a couple, have more than 6 million, you should be aware of the estate tax and you should consider whether you want to be making some estate planning moves that might help reduce any potential estate tax or not. You don't really need to unless you had more than 12 million. And if as a couple you have more than 12 million, then you should consider what the estate tax exemption going down to 6 million per person in 2026 would mean for you. And it is old news because that 2026 date was set in 2017 when the current tax law changed, but we just were hopeful at that time that Congress would act together, and now that seems less likely. The Secure Act, I talked about this in 2020 also. What Secure Act is that Congress in December of 19 shocked us and passed the Secure Act, which basically means that most people who inherit an IRA can't delay the distributions over their whole lifetime like they used to. So if you inherit an IRA from your parents, you used to be able to stretch your IRA distributions out over your whole lifetime. So maybe your parents had to take RMDs based on a life expectancy of 8 years, but then when they died and left the IRA to you, you maybe had 30 years that you could stretch your IRA over, or their IRA over. Under the Secure Act, most beneficiaries can only stretch IRA distributions over 10 years. So there are exceptions, such as someone who's not more than 10 years younger than you. So if you named a sibling as an IRA beneficiary, frequently they can still stretch over their lifetime. Your spouse can still stretch over their lifetime, and disabled beneficiaries can still stretch over their lifetime. The problem was that although Congress passed this act in 2019, the regulations didn't come out from the IRS or the Treasury Department. So we were sort of guessing as estate planners as to what our documents needed to say in order to allow our clients to stretch the distributions for the longest possible time. So in the end of February, we were thrilled when regulations came out. And those were proposed regulations, and they were supposed to become final regulations in March. But guess what? We still don't have final regulations. So although we did get proposed regulations in February, and that's better than nothing, we still don't have final regulations. And they are already talking about Secure 2.0. So there's going to be a new Secure, possibly before we even know how to properly draft our trusts under the old Secure. But you should just be aware that your beneficiaries under your retirement plan may not be able to stretch the distributions out for as long as you intended. And if you'd been told in the past that a special needs beneficiary, like a sibling or a child who has special needs and maybe has a trust set up for their benefit, you were probably told in the past not to leave IRA type assets to those special needs trusts. And you may be able to leave IRA assets to those trusts now. In fact, they may be preferred beneficiaries in some situations. So it's something you should talk about with your attorney. So you should all have beneficiary designations. Typical beneficiary designations that are easy to do are your life insurance and your IRAs, 401ks, 403bs, because they make it really easy to designate beneficiaries for those things. What you may not have thought about are your bank accounts and your HSAs. So you want to be sure that you have transfer on death beneficiaries set for your bank accounts. The bank accounts, you do not want to make joint. So these are people, you want to designate somebody to receive your account when you die, not somebody to own the account with you right now, unless it's somebody who you really intend to be able to access the assets and you want them to have full access to the assets right now, and you're not worried about their potential creditors. Because if you add a joint tenant to your bank account and then that joint tenant gets sued, their creditors can go after your bank account, even if the joint tenant never actually contributed anything to it. So it's generally better to have a transfer on death beneficiary for your bank accounts instead of a joint owner. Ladybird deeds are another typical beneficiary designation. So those now are basically transfer on death deeds. They're also called enhanced life estate deeds. And so with your Ladybird deed, you can say that you're deeding your property to yourself for your lifetime. And if you still own your home when you die, you want that home to go to your kids, or you want that home to go to your sister. And all that your beneficiary has to do then to own the home is record your death certificate. So these beneficiary designations are a great way for you to work on your estate plan right now, for the most part, for the top 4, without even talking to an attorney. You shouldn't try to do a Ladybird deed on your own because they are complicated and they're easy to, I guess, mess up. So that if you do one little thing wrong, then you're actually giving the beneficiary an interest in your property right now. So I would recommend working with an attorney to do the enhanced life estate deed, but you should check your beneficiary designations. And those people in the corner are saying, what's a contingent beneficiary? You want to be sure if you have your spouse named as your primary beneficiary on your life insurance and your IRAs and possibly even your HSA, on those type of assets, you can name a contingent beneficiary really easily. And they might call it an alternate beneficiary or a remainder beneficiary, but you want to be sure that there's somebody else named to receive your assets if the first person that you designated as a beneficiary dies before you. And if you do have a trust, you can designate the trust as the beneficiary. But what if you want to leave money to children or grandchildren who are minors and your kids aren't all responsible, or you're worried about a divorce, or if you just have a ton of kids and it's hard to designate 8 kids as the beneficiary of your Chase account, or if you want to have a backup plan for who gets your assets if someone dies before you, if you want to be sure how assets are held for your grandchildren if one of your kids dies before you, or if a grandchild or child has special needs, then in that case, you shouldn't just rely on beneficiary designations, and you should talk to an attorney and have an estate plan put together. So the documents in a typical estate plan are a will, the trust, which you may or may not need, an assignment to the trust, which is how your personal property, like the stuff in your house, gets into the trust, a list of personal property, which you can do. And again, this is Michigan specific. You can probably do this in most other states. You can make a list of personal property that you can change on your own without amending your trust, as long as you sign it and date it. And that way you can decide who gets certain items whenever you want. Enhanced life estate deeds are usually included in an estate plan. The general durable power of attorney is the most important one, really, because that's what's going to keep you from having to have a conservator appointed for you if you were to become unable to manage your assets yourself. Patient advocate designation is a medical power of attorney. If you're in another state besides Michigan, you can probably sign a living will. There's only 3 states, including Michigan, where you can't sign a living will. And so you should consider that. A HIPAA waiver is saying who's authorized to talk to your doctors and view your medical records, and those are important as well. In Michigan now, we can designate a funeral representative, which is saying who can make funeral and burial decisions for you after your death. You may need a delegation of parental authority, and that would be if you have minor children and you wanted to authorize somebody else to be able to authorize medical treatment for your minor children while you're away. So given who I'm talking to here, being mostly retirees, you should think about your kids having a delegation of parental authority if you're going to be babysitting the grandchildren while your kids go on a big vacation. And then the last is the appointment of guardian. Again, this would be if you had a minor child, or also if you have a child who's expected to need a guardian as an adult. You can designate a guardian through your estate planning documents. So there are a lot of facts and a lot of myths about estate plans. A lot of people come into my office and say, well, I have a will, so I'm not going to need probate. And that's absolutely false. So wills equal probate. You avoid probate by having your assets designated to transfer on death to a person, or having a joint owner, or having your assets owned by or transferring on death to a trust. Another myth is that you don't need a trust if you have, if your assets are below a certain level, and there is no magic level. You need a trust if your beneficiaries aren't appropriate recipients of everything outright as beneficiaries of the assets. So if you don't want to designate your life insurance, say, to go outright to your kids or to the people who you want to leave it to, then maybe you need a trust to manage your life insurance. The last myth, and I'm sure there are more, is that trusts are really complicated, and they don't have to be, and trusts can be in plain English. Sometimes my clients come in with trusts this thick and they have no idea what they say. You just want to be really sure that if you're signing a trust, you know what it says, you know what it means, and if the attorney is telling you, oh, don't worry about it, it all makes sense, it's just a bunch of legal words, just sign here, you don't want to sign that. You want to be sure that you understand your trust and you can explain it to your kids and to the people who you want to name as the trustees. So if you want to leave money to your children and grandchildren who are minors, and you're worried about your kids being responsible, and you want to avoid probate, then you need a trust. So you can take care of all these people just through your will. So you can say in your will that I want to hold my assets for the benefit of my kids and give them 10% each year for the next 20 years or something like that, so that you're doling your assets out over time. But then a probate estate stays open for the entire time if you're doing those things in your will. You can do them instead in a trust, in which case you would probably only have what we call a pour-over will. And the pour-over will just says, upon my death, if anything goes through probate, then I want it to go to my trust. And so then nobody reading your will, because wills are public records in Michigan, and as far as I know in every other state, if they're probated, anybody reading your will wouldn't know who the beneficiaries are and wouldn't even really know what the assets of the trust are. They would only know what assets needed to go through probate. So having a trust keeps your assets a little bit more private too. Are two trusts better than one? You may have talked to your neighbors, and maybe your neighbors have two trusts, and that was really common in the late 90s, well, throughout most of the 90s and the early 2000s. And that's because the estate tax exemption was so low at that point. So you might remember the fiscal cliff that we were going to fall off of in 2010, where the estate tax exemption was going back down to $1 million. So a lot of people who did estate plans in 2010 probably do have two trusts because their attorneys were worried about how to allocate assets between them so that they'd be minimizing the estate taxes. Now with the estate tax exemption so high, fewer people need two trusts. And for the most part, most of my clients do use joint trusts. Joint trusts are appropriate if, oh, you know what, I'm missing a word here. It should say, are you and your spouse both the parents of all the same kids? If that's the case, then a joint trust will probably work. Do you own all of your assets jointly? If so, again, then looking at a joint trust works. Do either of you expect to inherit? And if you plan to inherit, are you planning to keep those assets separate from your spouse? That might be a reason to have two separate trusts instead of a joint trust. Or you might have a joint trust to hold all of your joint assets and a separate trust to only hold the assets that you inherit. And maybe that separate trust would say, whatever I inherit from my parents, I want to pass to my kids on my death, even if my husband's still alive. Do you have more than 6 million combined? And if my clients do have more than 6 million combined, we're talking about two trusts. We're not necessarily going to two trusts because even in 2026, when the exemption goes down to 6 million, it's still 6 million per person and not 6 million per couple. So if my clients do have more than 6 million, but they are parents of all the same kids and they do own everything jointly, then we still frequently are going with the joint trust and not separate trusts. Do you have any special needs beneficiaries? Then you might need two trusts, not because you want to keep assets separate from your spouse, but because you want to have a separate special needs trust for your special needs beneficiary so that maybe other family members can leave assets to that beneficiary as well, or so that you can allocate maybe life insurance to pass directly to the special needs trust, which would continue for longer than a joint trust. So if you don't have the same kids, the reason that I ask that is that if you have remarried and you each have separate kids who you want to be beneficiaries of your own estate, you could have two separate trusts. And your trust might say, upon my death, I leave 1/3 of my assets to my spouse and 1/3 to each of my two kids. Your spouse's trust might say, I leave everything to the Detroit Zoo. And that's okay. You can do that if you have two separate trusts. But if you want to leave your assets half to your kids and your spouse wants to leave their assets to the Detroit Zoo, then a joint trust might not work for you, because even though your joint trust could say that half goes to the kids and half goes to the zoo, one of you is going to die before the other. And with a joint trust, the survivor can generally amend the trust to change the beneficiaries. So if you want to be sure that the beneficiaries who you intend to receive your assets actually do, then going with a separate trust generally does make sense. The special needs trust can be standalone or can be part of your primary trust, so your joint trust or your individual trust. It can be revocable or irrevocable. Most of these now are revocable just because the laws and rules around special needs trusts are changing so much lately. It can be part of a grandparent's trust or a sibling's trust. There's not just one person who's authorized to create a special needs trust for your child. So it's possible that one of your siblings has created a special needs trust for your child because they plan to leave assets to your child and they want to be sure that they don't interfere with the government benefits. So whether you go with a standalone trust or a sub-trust within your primary trust, whether your trust is revocable or irrevocable, the common elements of these trusts are that the trustee is authorized to make distributions on a purely discretionary basis. So because of that, the trustee doesn't have to pay creditors. The trustee can decide who to pay and who not to pay. The trustee should also not be directed to make distributions for the beneficiary's health support or maintenance, which is something that normally does happen for your other beneficiaries. So if you just have a typical minor beneficiary, you would probably direct the trustee to make distributions for those purposes. But with the special needs beneficiary, we're expecting that the government benefits will be paying for health support and maintenance, and we don't want to make distributions or direct the trustee to do things that would interfere with the government benefits. The other element of these trusts are that all of the assets should be from a parent, from a neighbor, from a sibling, from anybody other than the person who the special needs trust is for. So the government benefits that the special needs person is receiving should not be going into this trust. And anything that is left directly to the special needs person, so if, let's say, a well-meaning aunt dies and says, well, I want for $25,000 to go to Tom, and Tom is a person who's receiving government benefits and he's disabled, Tom can't just say, okay, well, now I'm going to put those assets into the special needs trust that my parents created for me, because that would be a completely different type of trust where whatever Tom receives, Tom can put in a special needs trust for his own benefit, but then those assets have to be used to pay back for his government benefits that he received after his death. Any trust that you set up for a special needs person using your own assets can have anybody you want as the remainder beneficiary. A special needs trust will also usually have a trust protector who can update the trust if the laws change, and also have termination provisions. And this is something that changed with Secure. So before the Secure Act, most special needs trusts said that if the law changes to such an extent that this trust counts against the special needs beneficiary and prevents them from qualifying for benefits, then the special needs trust shall be terminated and all of the assets will be distributed to my other kids or to anybody else. Now with Secure, we believe, because remember the regulations still haven't been finalized, that if there are assets in that trust that to which Secure applies, so IRA, 401k, Roth type assets, that upon termination, all of those assets have to be distributed to or for the benefit of the special needs beneficiary. At the bottom, I say maybe you just need ABLE. So what ABLE is a 529 plan. So you may be familiar with the 529 college savings plans. More recently, Congress authorized ABLE, which stands for Achieving a Better Life Experience, to allow savings for people with special needs. So either they can create an ABLE account themselves and put money into that ABLE account to use for whatever they want, or another person can do that for them. The tricky piece to it is that there are limits on how much can be put into the ABLE account. Generally speaking, it's about $15,000 a year that a third party can put into an ABLE account. If a person with special needs is contributing to the ABLE account themselves from money that they're earning by working, they may be able to put a little bit more in. So establishing an ABLE account is really easy. You can go online and get it set up. And then the person with the ABLE account can have a debit card to be able to spend money from the account. And the debit card has certain restrictions on it so that they can't use it in a way that does interfere with their benefits. The assignment to the trust was one of the pieces that I talked about as a part of your estate plan. What that's doing is that's just saying my toaster and my couch, all of my stuff that doesn't have its own title, all of those things I want in my trust too, so that your estate doesn't have to be probated for your personal property. And then we talked about that list of personal property. And in Michigan, what you can do is if your trust or your will says that you might make a list of personal property and that you might update it from time to time, You can do that without talking to a lawyer or without having witnesses. You can do it on your computer. You can do it by hand. You just need to sign and date your list of personal property. And some of my clients have made a hobby of this. Some of my older clients seem to really like making lists and updating them from time to time to say who gets specific items throughout their house. And those are actually the things that people wind up fighting about. So if there's anything that you feel your kids are gonna fight over, you could list those things on a list of personal property so that you are saying who can receive them. I just got a chat to say to remember to send your questions to us using the questions box. I think you may have gotten that chat too, so it probably went to everybody. But just a reminder, what is a ladybird deed? So this is a hummingbird. I don't know what a ladybird actually looks like. The myth is that a ladybird is they're called ladybird deeds because Ladybird Johnson used those deeds. I guess that's actually not true, but anyhow, what a ladybird deed is it's an enhanced life estate deed, which is a transfer on death deed. But for some reason, Michigan and some other states are very opposed to saying it's a transfer on death deed. It's an enhanced life estate deed. But the effect is the same. You own the property until your death, but you're saying who gets the property upon your death. If you want to leave the property to more than 2 people, I would really recommend using a trust instead and naming the trust as the beneficiary of the enhanced life estate or ladybird deed. Just because if you're leaving the property to a bunch of different people, they're going to have to work together to sell that property and nobody's in charge. Additionally, if one of those beneficiaries were to die before you, I would recommend strongly that you update your enhanced life estate deed so that you're clear on who you intend to get the property, whether you intend for your deceased beneficiary's estate to get the property, or whether you intend for it to go to the surviving beneficiary who you named. You should be clear about that. Powers of attorney are the most important thing that we do, and that's really, if you take nothing from this, go out and sign a power of attorney. So your general durable power of attorney is saying that somebody else can do things for you if you can't do it yourself. And before COVID, we were having most of our clients sign powers of attorney that were springing, saying, you know, yeah, I want my kids to be able to pay bills for me and everything, but not if I'm competent. I don't want my kids to be able to access my bank account while I'm competent. I want them to have to get letters from my doctor saying I'm not competent to do that myself. During COVID, that got really hard because you couldn't get in to see your doctor, let alone your kids getting in to see your doctor and then being told that your doctor's not going to write that letter until the doctor meets with you. So I guess the good guidance on the durable powers of attorney are, number one, you shouldn't name anyone who you don't trust completely to manage your assets. And number two, if you do trust them completely, then please consider not requiring them to have to get letters from your doctors before they can act, because it can be a significant hurdle and it can be time consuming. Number two, I say living will with a question mark, because Michigan, you'll remember, is not a living will state. What a living will is it's an agreement between you and your doctor that is saying that you don't want life support, and your doctor can actually hold up that paper. Even if your kids are saying, please, we want her on life support, the doctor can say, no, your mom signed this and I'm not permitted to put her on life support because of this. Michigan, being not a living will state, is a patient advocate state. So in Michigan, you can name your patient advocate and you can tell them what you want them to do, but you can't make them do it. And so you want to name a medical decision maker who you feel is going to follow your wishes. And so if you say on your patient advocate designation, which is an advance directive, that you don't want life support under most circumstances, your advocate can still put you on life support, or your advocate can talk to your doctors and make the best decision based on the circumstances. But in Michigan, your advocate has a lot of authority because they listen to what you say or read what you say, but they don't have to do that. The HIPAA waiver is saying who's authorized to talk to your doctors and get information. And it's important that you have that, because you'll know when you go to the hospital and you're visiting a friend, sometimes there's a chatty nurse who will just tell you everything. But other times the hospital won't even tell you a room number, or won't tell you if somebody is a patient at that hospital, because they feel that it's a HIPAA violation. And unfortunately, it's really up to who answers the phone, because we don't have a lot of clarity, as you all heard, about the whole vaccinations and whether you're vaccinated is a HIPAA violation. It's not. If you tell people that you're vaccinated or not vaccinated, you're not violating HIPAA. And if somebody asks you, they're not violating HIPAA. But a HIPAA waiver is a good way to make sure that the people who take you to appointments, who may be your kids or maybe your friends or neighbors, are able to get information from your doctors about what's going on, so that if you start acting funny after a doctor's appointment, they can call and say, something's not right, what happened? And then they could find out, oh, you're on a new medication now, and you shouldn't be working outside, or you shouldn't be drinking alcohol, and your neighbors could help you with that. The funeral representative is a new thing in Michigan, where now you can designate someone to make funeral and burial arrangements for you. Before, you could not do that, and it was a really big problem, because the only people who were authorized to make funeral and burial decisions for you were your closest living family members. So for instance, if you have 3 kids, and 3 of your kids, or 2 of your kids, are going to do exactly what you want, because you want to be cremated and you don't want there to be a big to-do, but you know that the 3rd child doesn't believe in cremation and feels strongly that you need to be buried, then you probably need to designate a funeral representative. Because if your kids aren't all going to agree together as to what you would want them to do, then you want to designate the person who you think will do what you want to be your funeral representative. If you don't have kids, and you don't have living parents, and you're not married, and you don't want your siblings making these decisions for you, then you also need a funeral representative. Again, this may be very different in other states, but in Michigan, if you don't name a funeral representative, the decision-making is up to your closest living relatives. The appointment of guardian and delegation of parental authority for this group, I think, is really going to be more important when you're babysitting grandchildren. And so you want to ask your kids, have you named a guardian in your wills? Because if your kids didn't designate a guardian in their estate plans, then there could be a fight about who their kids live with if something happened to your kids. And if you want for your kids to be clear, and you want to know who's going to be taking care of your grandchildren, which is perfectly reasonable, you should encourage your kids to be appointing a guardian in their documents. The delegation of parental authority is something that you should be getting from your kids when you're babysitting the grandchildren, especially overnight, or if it's going to be for a week, for a vacation, something like that, because this is what would let you authorize medical treatment for your grandchildren. Otherwise, if the grandchildren were injured, if it's an emergency, the hospital will absolutely treat them. But if it's just something like a broken arm, where is it an emergency, or should we wait till we talk to the parents to see how they want this treated? It's better for you to have the authority so that you can make decisions. The bad thing with the designation or delegation of parental authority in Michigan is that it's only allowed to last for a maximum of 6 months. It has to be signed by both parents, and it has to be notarized. So it's a pain in the neck for your kids to do if they want for you to continually have this authority, but it's very important for you to have. Tough decisions, if you are going to be doing your estate plan. These are the things that I ask that people don't have the answers to when they come in to meet. Who should be in charge of your estate? So who do you want distributing the assets? You want somebody who's going to be fair and somebody who's going to do what you say. Who would you want to raise your grandchildren? That's where I'm saying you don't maybe need to tell your kids who the guardian should be, but you do want to be sure that you're getting them to do estate plan themselves. Who should make medical decisions for you? A lot of times my clients feel that this should be their kids in order of age. Well, if your oldest child is an accountant and your youngest child is a physician, that doesn't make any sense. You should be looking at your medical decision makers based on who's going to be a good advocate for you and who has good medical experience. Who are the beneficiaries? So you might say, I want everything to go to my siblings equally, or I want everything to go to my children equally. And that's fine. But then what if they have died? You've got to think through, what if those people don't outlive me? Then who do I want the beneficiaries to be? This disaster beneficiaries is something that's a stumper for just about everybody. And so if you're telling me that you want everything to go to your kids, and if your kids aren't living to the grandchildren, then I'll say, okay, well, what if you decide to take the whole family on a cruise and the cruise ship sinks? Then who do you want to get your assets? So, we almost never need to read that paragraph, and it very, very, very rarely becomes important. But if you do have a small family, if you have an only child who has an only child, then it becomes important. So think about that. And then it's also very tough to designate beneficiaries when you're in a second marriage situation. And so if you want to be sure that you're providing for your children and your spouse wants to provide for their children, and you still want to provide for your spouse, that can be tough. That's one reason that you might want to consider a prenuptial agreement. So the benefits to the prenuptial agreements are that you can keep your assets separate. You can reassure your adult children that your significant other is really not just trying to get your assets, and you just can reduce uncertainty. Your kids would probably be more trusting of your future new spouse if they feel like everything's taken care of. So most of my clients who do prenuptial agreements are your age. So most of them are people who have adult children of their own, and they're coming, each of the spouses or potential spouses are coming in with assets, and they want for those assets to go to their own children. Sometimes they want something to go to the spouse, and when you are going to be buying a house together, that becomes complicated because you probably want for your spouse to be able to continue living in their house after your death. But it's a good idea to sit and think about this. And recently there was an article in the New Yorker saying that the millennial generation is all about prenuptial agreements, and they're signing them all the time. So your kids may feel more comfortable with the idea of a prenuptial agreement than you do, but it's something that you should consider if you're looking at remarrying. But unfortunately, the prenuptial agreement won't help if your spouse needs Medicaid. So in Michigan, and I believe in all other states, if you are married and your spouse needs Medicaid, they're going to consider the whole family's assets. So your assets plus his assets, even if you have a prenuptial agreement, it just doesn't matter. So that's one reason that sometimes people don't get married when they're looking at potentially needing nursing home care in the future, is that if you're not married and one of you needs nursing home care, then the state is only looking to the person who's in the nursing home's assets and not the couple's assets as a whole. So, just one more consideration. What do your parents need? So I know a lot of my retiree clients still have parents who are living and don't have estate plans. So if you're going to be talking to your parents about what do they need, that number one thing, I've got this in order of importance, is that financial power of attorney. So you want to be sure that your parents have designated someone, and it doesn't have to be you, as a person who's authorized to pay bills for them or choose their nursing home or sign a contract for them. Because otherwise they're going to need a guardian appointed, and we don't want that. A guardian means probate court is involved. So we want them to be designating someone, and it could be their spouse and then a backup, as their decision maker if they can't be making decisions for themselves. That Ladybird deed is very important. So in Michigan, if you're looking at Medicaid and going to a nursing home, your house doesn't count against you. But if you put your house in a trust, it does. So that's why the Ladybird and Enhanced Life Estate deeds became so important in Michigan, was that they were a way of keeping your property in your name so that your house doesn't count against you for Medicaid, but then still having it transfer on death to somebody else, so probably to your kids, so that they don't go through probate. So in Michigan, any assets that go through probate are subject to Medicaid recovery, meaning that they have to be used to repay for Medicaid benefits. So doing the Ladybird deed to you or to you and your siblings will keep your parents' house from being subject to Medicaid recovery. You also want to be sure that they have beneficiary designations on everything, on their checking account, on their savings account, on any old insurance. Make sure their beneficiaries are alive. So, if your dad died years ago, but your mom still has your dad as the beneficiary on something, you want to make sure that she's changed that. You could consider whether they need a trust to keep everything out of probate. And so if the beneficiary designations are too cumbersome, if you have a special needs sibling who your mom wants to provide for, if you've got too many siblings, you've got 8 or 10 siblings, and it just is too much to be designating them all as beneficiaries, then maybe your parents do need a trust. That medical power of attorney is next, especially if you don't think that all of the siblings would agree with each other on what medical treatment is right for your parents. And that's the same thing with the funeral designation. If you guys aren't going to all get along and make funeral and burial decisions together well, then you want your parents to designate a funeral and burial decision maker. The will is the least important document because don't forget, we want to avoid probate. That's why we want to do number 1, number 2, and number 3, and number 4. That's all about avoiding probate. The will only controls assets that go through probate. And if your parents are going to say, I leave everything to my spouse, and if my spouse isn't alive, everything to my kids, and then I want one of my kids to be the personal representative, they don't even need a will, because that's what would happen under the law, at least in Michigan, if they didn't have one. If your parents have remarried and they have a new spouse, then you want to be sure that that they've signed a HIPAA waiver authorizing you to talk to their doctors. You want to be sure that you can't be shut out from hearing what's going on with your parents if they are remarried. Also ask if there's a prenuptial agreement. There's no harm in asking that, and find out what everyone's roles will be. If you talk about it in advance, then it's much better than finding out at the hospital that the new spouse is the medical decision maker when you always thought that you were. So it's much better to talk through in advance what they have in terms of paperwork. If they're not comfortable talking about their assets, that's okay. Just make sure that they have beneficiaries designated for everything. What should your kids have? Well, they should have a HIPAA waiver too. And it would be great if they did say that you can talk to their doctors. If your kids are in the 18 to 28 range, they're probably fine with that. If they're not married, they need somebody who should be able to talk to their doctors to get information if they go to the hospital and they're unconscious. You could fax over the HIPAA waiver, you could email it, you could take it there yourself, but that way at least the doctors would know that you're authorized to find out what's going on. They should have a financial power of attorney saying that somebody, and it doesn't have to be you, can access their assets or enter into contracts for them, sign an agreement to go to a nursing home if they needed rehab. You just need to be sure that they've got somebody authorized to do that, even if they don't want it to be you. The medical power of attorney is also important. We've talked a lot about the appointment of guardian for their kids. You just want to ask them, have you designated somebody? Because if the worst happened and your kids died and your grandchildren need a guardian, you just want to be sure that they have a place and that there's a plan. And then that delegation of parental authority, if you're going to be babysitting, you want to have that so that you know you can authorize medical treatment. What do you need to change if you have an old estate plan? You want to check about, we talked about secured with the eligible designated beneficiaries. You want to consider whether you have a preferred beneficiary named as an IRA or 401k beneficiary. You may not want one. If you really want for all your IRA assets to go to your kids, that's absolutely fine. Just realize that they're limited to a 10-year stretch. Otherwise, if you had been told in the past that you shouldn't be naming somebody close to your age, some people were told for years that they should name their nieces and nephews instead of their siblings, even though they really would have preferred for their IRAs to go to their siblings. Think again about your siblings, especially if they're not more than 10 years younger than you. So if they're older than you or not more than 10 years younger, they'll be able to stretch too. Check your beneficiary designation. So even if you think that you have beneficiaries designated, banks are terrible at this. They are constantly losing beneficiary designations. You want to check and make sure that you do have beneficiaries named on everything. And wherever you can, that you also have contingent beneficiaries. Check your documents. If you refinanced, so let's say that you did do an enhanced life estate deed or a Ladybird deed, but then you refinanced. A lot of times the banks will have you sign a quitclaim deed transferring the house back to yourself, even though you owned it all along, just because they don't really understand these enhanced life estate deeds. So if you refinanced, you want to check and make sure that your house is still set up to be in your trust or go to your trust or go to beneficiaries. If you want to leave assets to charity, you just want to check and consider whether you want to do that through your trust or your will, or whether it might be better to do that through an IRA beneficiary designation. You can designate the charity as an IRA beneficiary, and then taxes are never paid on those assets that go to the charity. If you instead have the charity named to receive assets in your trust, then what that might mean is you're leaving IRA assets to your kids and they have to pay taxes, and then you're leaving post-tax assets in your trust to the charity. And that doesn't make sense if you are at all interested in tax avoidance. If you want to disinherit a child, the law changed in Michigan somewhat recently that you need to be really clear about that in your will. So now in Michigan, if you don't expressly disinherit a child, that child can claim $15,000 from, I think it's actually $16,000 this year, from your estate or even from your trust as exempt property. And so there's just a statute that says that your children are entitled to $16,000 of contents of your house, so your toaster and your couch and all that, and that if you don't have personal property worth at least that much, they're entitled to assets from your estate or from your trust of that amount. So if you don't want a disinherited child to get that, you have to be clear about that. And also, have you updated your documents since 2012? That's 10 years ago, so it's probably about time to get them looked at anyway. In Michigan specifically, powers of attorney rules changed in 2012. And so if you did sign your power of attorney in 2012 or earlier, you probably need to get those updated because you're not going to have the acceptance language that the banks are looking for now. We talked before about the springing durable powers of attorney, and that's what everybody was using before COVID. I've sort of highlighted this box here saying, you know, I'm naming my daughter to act as my agent under power of attorney, but I want her to have to get letters from my doctor before she can act. And that's been problematic. So if you do have a springing durable power of attorney, I'd like you to consider not requiring your agent to get letters from the doctor before they can act. Do you have an estate tax issue? You probably don't. So most people are below 12,060,000 and most couples are below 24,120,000. But if you do have an estate tax issue, then you want to take it seriously. I mean, the estate tax is about, they're saying here, 46%. It's really going to be closer to 40%, but then there are states that have estate taxes as well. So if you do have an estate tax issue, you want to be more thoughtful about what you're doing. These are the states that have specific estate taxes. So the pink ones have an estate tax, meaning that the tax is on the dead person's estate. The green ones have an inheritance tax, meaning that if your beneficiaries live in that state, they may pay taxes based on what they inherit. And then Lucky Maryland is both. So Maryland has both an estate tax and an inheritance tax. So if you do have beneficiaries in any of these green states, or if you live in any of the pink states, you need to be more cautious about estate taxes, because although you need to be aware of the 12,060,000 federal exemption, like in Illinois, for instance, you're going to be paying a state estate tax if you're above 4 million, in Minnesota above 3 million, in Oregon above 1 million. So, got to think about it. Portability and the joy of filing an estate tax return. This is what I talked about, that if your spouse dies and if you are at all concerned about estate taxes in your future, then even if you don't have to file an estate tax return, maybe your spouse only had $1 million in assets and you are 100% not required to file an estate tax return, you can file that return this year and reserve your spouse's $12 million exemption. So what that means is that if the exemption does go down to $5 million in the future, but your spouse died this year and you filed an estate tax return, then when you later die and the exemption is only $5 million, you can actually have $17,060,000 and not pay estate taxes if you filed the return for your spouse. So there wouldn't be any taxes owing because everything, your spouse is below the exempt amount. It's a hassle to file the estate tax return. It's a little bit easier when you're doing it just to claim portability, because you don't need to get exact valuations on all of the assets. You're basically signing an affidavit saying that everything's about right, but you have a little bit more fudge room. You don't need to get all of the assets appraised, for instance. But yeah, if you're concerned about the estate tax exemption getting lower in the future, and your spouse dies before you, consider filing an estate tax return for them, even if it's not due, just so that you can reserve their exemption. You can also avoid estate taxes by leaving gifts to charity. This is through your required minimum distributions. You can make those payable directly to charity, and you can avoid some income taxes this year. You can designate a charity as the IRA beneficiary on your death, like we talked about. Excuse me. And so then the IRA assets would go directly to the charity. You can contribute to donor advised funds. So for instance, if you are going to have a big capital gain this year because of a stock sale or something like that, you can contribute money to a donor advised fund that you can create through Schwab or with your broker. And you get to take the tax deduction on the amount that you contribute to your donor advised fund this year. And then you can distribute money to the charities that you normally donate to from that donor advised fund in the future. The money doesn't all have to be distributed in the year that you add to the donor advised fund. You can also, of course, name a charity as a beneficiary of the trust. You can create or contribute to a scholarship fund. CRATs and CRUTs were under fire in October. CRATs are charitable remainder annuity trusts, and CRUTs are charitable remainder unit trusts. The benefit of those are that you create them during your lifetime, you get a tax deduction when you create them, and then your beneficiaries either wind up getting what's left or they get an annuity, and you also can get the annuity during your lifetime. Those were going to be problematic under Build Back Better. As far as I have heard, they are not an issue under the Inflation Protection Act. But again, we don't know all the final details of that yet. I'm just about out of time, but let me go through really quickly. These are the steps to probate administration. You're going to be getting the death certificate. There is nothing you can do until you get the death certificate. And that's taking about 10 days in Michigan. So, you don't have to call me the day mom dies, and you don't have to call me the day of the funeral. Wait until you get the death certificate, and then we can help. Then figure out if there's a will. And if there is a will, it's a whole lot easier to manage the estate if you can find the original. Then you have to file forms with the court. But don't forget, you're only doing this if you've realized that your parents or whoever you're opening the estate for has assets that are only in their name without a beneficiary designated. So when someone dies, don't automatically assume that there's going to have to be a probate estate. There may not be. In Michigan, the forms are available online, and if you're comfortable filling them out yourselves, you absolutely can. You do not need an attorney. You then would file the forms at the court, and right now, due to COVID, it's all different. Wayne County will not let you in. You have to file them by email. Most other counties let you in, but also accept them by mail, but not by email. So you should check the court's website to see what the options are for filing and whether you have to go there. Then you're going to need to send copies to the heirs at law and the devisees. And that can be problematic because possibly somebody is an heir at law, meaning they're a closest living relative, but they're not a devisee. So they're going to find out that this person created a will and designated beneficiaries, and they're not one of them. So because they're one of the closest living relatives, they have a right to object. Then you're going to need to publish the notice to creditors, which in Michigan gives creditors 4 months to come forward with claims against the estate. You've got to get a tax ID number for the estate. So any assets that are going to be in the estate are going to be retitled using the tax ID number of the estate instead of the deceased person's social security number. Then you've got to figure out what the assets are. So now that you've got a tax ID number and the estate's open and you've got a death certificate, you'll be able to go to the bank and find out how much is in this account. In Michigan, an inventory is due 90 days after you open the estate. You then are going to need to pay taxes for the decedent. So if the decedent died, the dead person died in July, they're going to have to pay normal income taxes for January through July, or at least file a return, and they might possibly get a refund. Then you may also need to do an income tax return for the estate, especially if there's an IRA payable to the estate, or if there's going to be significant dividends or capital gains in the estate. And so that's called a Form 1041. Before you close the estate, you'll prepare an accounting and you'll distribute the assets, and then you're ready to close. For the trust, similar steps. You've got to figure out, it's different if the grantor is dead or alive and if the grantor is competent or not. So chances are, if it's your trust and you're alive, you're just treating it like normal. If the grantor is alive but no longer competent, then there are different requirements about who's entitled to notice about the assets and what's going on. I put in orange, read the trust twice. The trust says what to do, and the trust says what you are not allowed to do. And so you want to be sure that you actually read the trust, make a copy of it, and highlight it. Find out who the beneficiaries are and everything that you have to do, because the trust dictates what you have to do. In Michigan, when the grantor dies, you should, and the statute says you're required to, publish notice to creditors. That limits the time that creditors can come forward. You need to inform the beneficiaries that they are beneficiaries within 63 days. If there are charities as beneficiaries, you need to inform the Attorney General. You'll also need to get a tax ID number for the trust. You'll also need to figure out what the assets are. Then you've got to do what the trust says. If the trust says, don't distribute the assets to my kids, they have to wait until they're 60, then you can't distribute the assets to the kids until they're 60. You have to do what the trust says, or you can be sued as the trustee. That kid who got the assets when they were 45 because you were being nice, but then blew them by the time they were 50, is going to sue you if the trust said to hold the assets for them until they were 60 and you distributed them earlier. You've also got to consider what should be paid within the tax year, because you can pass the income taxes through to the beneficiaries on a K-1 if you are making some distributions to the beneficiaries. You'll need to again file the tax returns for the grantor and for the trust and prepare accountings. I think well, all right, I'll give you a quick Hyatt, but then we've really got to call it quits because I'm past 12 already. But Hyatt is still what I refer to. It's really now MetLife Legal. You may also call it Hyatt, but that's your legal plan that's available to you as a Chrysler retiree. The things that are covered are wills, trusts, but not tax planning for the trust, powers of attorney, deeds, but not for rental properties. If you're going to sell your house by owner, that's covered. Prenuptial agreements are covered. Some things are only sort of covered. When I say covered, that means MetLife Legal pays for it. If I do a deed for you that's paid for and I get a check from MetLife Legal, you just need to pay the recording fee. So in most counties, you'd need to pay about $30, $35 if I record it electronically. That's what I have to pay to the county for you to record the deed. But the deed itself is free to you, and I get paid by MetLife Legal. The things that are sort of covered are things like probate, divorce, consumer disputes, elder law. When I say sort of covered, that means you get a discount on it. You get 10% off, which is still better than paying full price, but you're going to be getting a bill from the attorney eventually. So consider the Hyatt Legal Plan, or now it is called MetLife Legal. I think your open enrollment is October, and you'd be able to sign up for it then. So I'm not going to have time to get into Medicaid today. But if you have questions specifically, feel free to contact me and we can talk through. If you're a Michigan person, I can put you in touch with somebody who can help you if I can't answer the questions myself. So that's all I have for you today. Thank you.
There we go.
Is Diana a member? Yes, I'm not a member like you would be a member, but I'm a plan attorney. And so yes, you can contact me. My name and address was on the first page of the presentation, but you can contact Hyatt or MetLife Legal, and they generally suggest attorneys to you based on zip code. You can ask based on name, but if you get attorneys who are recommended to you based on the zip code and you don't like any of those attorneys or none of them return your calls, you can always call back and get more attorneys also.
Okay. Well, that is right now the only question I have. If anyone has anything.
That was an easy one. Okay.
Yeah, well, I think it's in recognition that you did a fantastic job.
Thank you.
Very thorough and very informative. Really enjoyed listening to it. And
Right.
obviously, if you do have a question and it comes up later, feel free to just email webinar@ncro.org, and I'll see that it gets to Diana and that you get an answer. But thanks everyone for joining. And again, I apologize on the mix-up of registering. I think I got most people online as the session was going on. We had close to 40 members or so, including the planning team, that were on the webinar today. And it will be the recording of it will be put up on the NCRO YouTube channel. And I think with that, oh, wait a minute, I have another one here. Put this up. Just a second to get things out of the way on my screen. Never fails. We're only as good as the operator. Oops, I tried to copy and it didn't work. I think I know the answer to this question, but.
Are retirees eligible to enroll? Yeah, as far as I know, I have many Chrysler retirees who are enrolled. That's not true of all companies. I don't think my GM clients are able to enroll as retirees, but Chrysler seems to offer the MetLife Legal to everybody.
Just a little clarification, it is a benefit offered by Stellantis to retirees, but depending on when you started at the various companies that now make up Stellantis, if you started, I believe, after 2001 or 4, the benefits to retirees aren't the same as those folks that started earlier. So it may or may not be in the eligibility, but you'll know when you get the mailing in the fall to sign up. So that's the only caveat I can say. Now I think that's all I've got. Make this bigger. Yeah, some were hidden. My fault. So I got another one here. Just a moment. Paste it in. One of these days I'll have done this enough that it'll be slick and easy.
Yes, so the Social Security representative payee is needed even if you have a power of attorney. If you need a Social Security representative payee. So it is a completely different thing, and Social Security is not the biggest fan of powers of attorney. So yes, you do need to establish that separately through Social Security. It generally is the same person who you're naming as your agent under power of attorney, but yes, if the person is incompetent and not able to manage their Social Security, then yes, they would need a representative payee also. Yes, there is a benefit. The question is there a benefit on a Ladybird deed versus the house being in trust? So at least in Michigan, the benefits, there's two. So the biggest one for younger people, and I guess all people, is that in Michigan, when you own a house as husband and wife, it's called tenants by the entirety. And that's the best creditor protection that you can get. So if you own your house as husband and wife and the husband gets sued, he's in a car crash and he's getting sued and it's terrible, and he gets a judgment against him for more than his assets. In Michigan, the creditor can't make anyone sell the house until the wife dies, because the house is owned as tenants by the entirety. So the law would not imply that the creditor is entitled to half the value of the house or anything while the wife is alive. The couple gets to keep the entire house through the tenants by the entireties. And if you do put the house in the trust, you lose that tenants by the entireties protection. Again, not many people have creditors that are coming after them like that, but that's one benefit. The other benefit is that in Michigan, if your house is in the trust, it counts against you if you need Medicaid. So it counts as an asset that has to be sold and spent down before you would qualify for Medicaid benefits. If the house is not in the trust and you have a Ladybird deed, then the house can pass to your kids even if you get Medicaid benefits for years. In fact, you can even rent out the house, and a portion of the rent would have to go toward your patient pay amount, but the other portion of the rent could be used to help with the taxes and insurance and things like that. So the real reason why we started using Ladybird deeds a lot was so that we could keep the house out of the trust so it didn't count against a Medicaid beneficiary, but also avoid probate on the death by having the house go then to the trust or go to the kids so that there wouldn't be a probate estate. So that's our benefit of the Ladybird deed versus the house in trust. What's the average cost if you don't use MetLife? It all depends on what it is that you need. So for me, what I do when I meet with clients is that we don't charge for the first meeting, and then we figure out what is it that you need. Do you just need beneficiary designations and powers of attorney and a deed? Then maybe the cost for that might be $750 or something like that. If you need a full estate plan and you have two spouses and you need separate trusts and you both need powers of attorney and you've got a couple different properties, then we might be at $3,000. I would say the average cost for a couple to do a full estate plan without MetLife is probably about $2,200 to $2,400. Okay. Thank you.
That's what I was going to add. I think that concludes our questions. And I want to also just thank Diana and everybody that joined us today. This has been very, very informative, and I wish everybody a safe and healthy day.
You too. Thank you.